So again, I am issuing a oral motion to disqualify you.
You cannot do an oral motion to disqualify pursuant to the rules. Calling case C343540, State of Nevada versus Yuxia Zhang. I'm also calling case C343540, State of Nevada versus Kimball Austin Sachs. May I have appearances for the record of counsel that are here present in the courtroom?
You're ready for the state.
Good morning, Your Honor. Good afternoon. Shetler, 4747 from Ms. Zhang.
All right,
They should be online. They're there.
they are both online. Can I get your appearances for the record, please?
Agent for defendant Sachs.
Yuxia Zhang.
All right, and we are on, I will note for purposes of the record that this was a status check for Ms. Zhang's case. So, Mr. Shetler, do you have additional representations?
Your Honor, I sent over an order to your office on the getting the passport back. Rem is working on that with my office to get a proper version for you to have that.
Okay,
And the other issue, you're looking at me like I'm forgetting something, so please let me know.
no, I just hadn't seen that order yet.
Oh, okay, I thought so. Wait, it took some frustrating phone calls to the clerk, and I think I've got the right answer, but I
Okay.
won't know till I have your order.
Okay, the other thing that we were going to be finding out was to see whether or not there was additional information as to whether or not the child could or could not get the medical care in China. I think Ms. Zhang was going to reach out to the father. I don't know if that was done or not.
I don't have any information on that part yet. I know that there are other concerns they have about the order, but some of those will flow from what motions may or may not come after today's hearing, Judge.
All right. The court will note for purposes of the record that there was, let me just pull the case up because I want to get the exact, no, I have it in my notes. Mr. Sachs filed a judicial notice and reaffirmation of phoretic canvas and objection to third canvas that was filed last night. I don't know if the state was able to see that.
I did see it this
Okay. All right. We will address that first. There is also additional filings that were made that are set for November the 5th that are largely going to depend on what happens today in regards to the phoretic canvas. So I have a question that I need to ask of Mr. Sachs. So, Mr. Sachs, if you could unmute yourself, please.
I'm unmuted on my end.
Great. All right. So, you filed a judicial notice and reaffirmation of phoretic canvas and objection to third canvas in which you object to the court doing a third phoretic canvas, arguing that you had previously gone through 2 phoretic canvases and been qualified and should not have to go through a third simply because this court, i.e. this judge, does not know the record. As this department has made abundantly clear from prior proceedings, it is intimately familiar with the record in this case. I am very aware of the fact that you have gone through 2 prior phoretic canvases. However, because of the fact that the court, i.e. myself, needs to independently, I cannot just rely on what another judge's findings are. I cannot just rely on what another judge has done, especially since there has been a passage of time of over 2 years since the last phoretic canvas was done. This court believes that it is absolutely appropriate for the court to engage in another phoretic canvas. Additionally, there was a recent case that came out on October the 3rd of 2025 The case is State of Nevada versus the 8th Judicial District Court in and for the County of Clark and the Honorable Tina Talim, District Judge, and Lee Brian Kirk Jr., real party in interest. It is a 2025 Westlaw 2823624. It is an unpublished disposition, but I think that it is entirely relevant in this case based on what happened in that case. I will simply ask Mr. Sachs one question, and I would like a response to this question. Mr. Sachs, are you unwilling to engage in an additional Ferretta canvas at this time?
I have to ask the question for clarification. If I say I'm unwilling, then are you going to deny me my lawful right to represent myself with standby counsel?
Based on the case that I just cited, yes.
I object, but I will go through your Ferretta canvas with a very strong objection. I think this is dead wrong, and I will say this as well, that my understanding from reading Ferretta versus Ferretta canvas, that case, is that there's only 3 requirements: is that I knowingly, intelligently, and voluntarily waive my right to full-time counsel. And it's full-time counsel because, again, I filed a motion for standby counsel. So it's not as if I'm completely flying solo. And I spent the better part of last night and the wee hours of last night reading McCaskill versus Wiggins. And so I'm fairly familiar with what was said in that case. And I think it's a complete waste of this court's time. It's prejudicial because you're citing a case that's unpublished. And so let me ask the question, just so we get it on the record, other than this unpublished case, which is really not fair to me, and how can it be, say, considered persuasive because it is unpublished, is what other authority are you relying on that when you say that this court, meaning you have to hear from me personally, what other actual firm case law? Because I put a lot of case law in that judicial notice that you seem to just completely ignore.
I will get to that, but I would like to read for the purposes of the record what this case says. This is an emergency, since you have not had the opportunity to read it, and I would also like to make a point. The reason why, because I know that you were talking in the chat to my staff about me violating your due process rights by calling your case last. I very, very, very am not. If anything, I am upholding your due process rights because I know from prior interactions with you, Mr. Sachs, that you wish to and are allowed to make a record and talk. And so I wanted to give you the opportunity to do that without cutting you off and limiting your amount of time to speak, because I had other people in my courtroom and defendants that were here from the Clark County Detention Center and from the prison. And so that is why I made the decision based on judicial economy and actually protecting your due process rights to be able to make a record to call your case last. So I would appreciate in the future that you do not berate my staff by making the comments that I am violating your due process rights. That being said, based on the case, it says this is an emergency original petition for a writ of mandamus challenging a district court order granting real party and interest Lee Kirk Jr.'s counsel's motion to withdraw and permitting Kirk to represent himself notwithstanding his refusal to cooperate in a canvass under Ferretta versus California. The state seeks a writ of mandamus vacating the district court's order and directing the court to reappoint counsel to Kirk prior to trial, which is scheduled to commence on October 6, 2025. This court has original jurisdiction to issue writs of mandamus, and the decision to entertain a petition for such relief is solely within this court's discretion. Mandamus is available to control a manifest abuse of discretion or arbitrary or capricious exercise of discretion. The petitioner bears the burden to show that extraordinary relief is warranted, and such relief is proper only when there is no plain, speedy, and adequate remedy at law. We exercise our discretion to entertain this petition in the interest of judicial economy because it raises important legal issues in need of clarification. The district court's order is not independently appealable, and absent our intervention, a wasteful trial, appeal, and retrial would other result. The state argues that the district court manifestly abused its discretion by permitting Kirk to represent himself at trial when he did not make a knowing and voluntary waiver of the right to counsel. The state contends that the right to self-representation is not absolute, and while Kirk has filed numerous pleadings before the district court expressing his desire to represent himself, at most this establishes a voluntary waiver, not a knowing waiver of his right to counsel. We agree. The United States and Nevada constitutions provide that a person brought to trial must be afforded the right to the assistance of counsel before he or she can be validly convicted and punished by imprisonment. A criminal defendant also has a constitutional right to self-representation. An accused who chooses self-representation, however, must satisfy the court that his waiver of the right to counsel is knowing and voluntary. Rinetti versus State, 117 Nevada 330, 2001. To that end, we have directed the district court to undertake, quote, a specific, penetrating, and comprehensive inquiry of the defendant to determine whether the defendant understands the consequences of his or her decision to proceed without counsel, end quote. SCR 253, parens 1, an inquiry known as a phoretic canvas. C. Rinetti, 117 Nevada at 339. Although this court does not require, quote, mechanical performance of a scripted phoretic canvas, quote, we have nevertheless repeatedly urged the district courts to conduct a thorough inquiry of a defendant who wishes to represent himself and to make findings as to whether the defendant's waiver of the right to counsel is knowing, intelligent, and voluntary. Miles versus State, 137 Nevada, 747. Quoting Hooks versus State, 124 Nevada, 48, 2008. Further, the record must show that the accused was made aware of the dangers and disadvantages of self-representation. Rinetti, 117 Nevada at 338. Quote, a conviction obtained after an invalid waiver of the right to counsel, dash, that is, comma, one that fails to demonstrate that the defendant knowingly, intelligently, and voluntarily waived the right is per se invalid and is not subject to harmless error analysis. Miles versus State, 137 Nevada, 2021. While this court has recognized that a request for self-representation may be denied if the request is untimely, equivocal, or made solely for purposes of delay, or if the defendant is disruptive, we have not addressed whether such a request should be rejected due to a defendant's refusal of a phoretic canvas. Several courts in other jurisdictions, however, have concluded that a defendant's refusal to engage in the requisite canvas results in a waiver of the right to self-representation. That is from United States versus Pryor, 842 F. 3rd, 441, 6th Circuit, 2016, concluding that a defendant's rejection of further inquiry into his waiver of counsel justified a magistrate judge's termination of the colloquy and resulted in waiver of the defendant's right to self-representation. Citing to Rollison versus Wainwright, 732 F. 2nd, 803, 11th Circuit, 1984, determining that a defendant waived his right to self-representation when he abruptly walked out of the courtroom as the trial court attempted to conduct a phoretic canvas. People versus Lavity, 489 P. 3rd, Colorado, 2021, concluding that the trial court properly denied a defendant's request to represent himself, where the court inquired into his understanding of the charges against him and the range of allowable punishments, but the defendant repeatedly gave unresponsive answers or refused to participate in the proceeding. Thus, if a defendant wishes to represent himself, then he must unequivocally waive the right to counsel and submit to a thorough phoretic canvass to ensure the waiver is knowing, intelligent, and voluntary. But a defendant cannot assert the right to self-representation and simultaneously sow error into the proceeding by refusing the requisite canvass. Stated simply, a defendant cannot have it both ways. Here, Kirk repeatedly expressed a desire to represent himself, but adamantly refused to cooperate when the district court attempted to conduct a phoretic canvass, thwarting the court's ability to determine whether his waiver of the right to counsel was knowing, intelligent, and voluntary. As a result, Kirk waived the right to self-representation. Despite this, the district court granted Kirk counsel's motion to withdraw and ordered that Kirk would be permitted to represent himself. As the district court manifestly abused its discretion in so ruling, we order the petition granted and direct the clerk of this court to issue a writ of mandamus instructing the district court to vacate its September 29th, 2025 order and reappoint counsel to Kirk. I will go a step further in why this court is ordering an additional phoretic canvass in this case. Based on Junior versus State, Gallegos versus State, and based on hold on. Oh, in Hooks versus State, the court reaffirmed that a criminal defendant must knowingly, intelligently, and voluntarily waive the right to counsel. Trial court should conduct a careful canvass to ensure that the defendant understands the disadvantages of self-representation, including the risks and complexities of the particular case. Likewise, in Graves versus State, 112 Nevada 118, the court clarified that the test of a valid waiver of counsel is not whether specific warnings or advisements were given, but whether the record as a whole demonstrates that the defendant understood the disadvantages of self-representation. Contrary to Mr. Sachs's conclusion, he did, in fact, because he said in his motion that he filed last night, that he said that all he needs to do is to say that he understands the consequences of his decision, and that he is knowingly and willingly and voluntarily choosing to represent himself. However, if we look at the record in this case, the last time he made his decision was what later turned out to be a blatant misunderstanding of what standby counsel could do for him. Therefore, it is incumbent on this court to ensure that we do not reach the eve of trial as we did the last time, and Mr. Sachs decides that he cannot represent himself and asks for counsel, which led to a delay of the trial in this case. The basis of the court's doing an additional phoretic canvass in this case is to ensure through this new canvass that Mr. Sachs understands that this court is not going to engage in tactical manipulation. The court is going to use this opportunity to make sure that Mr. Sachs understands the finality of his new decision, whichever that decision may be. The court is also going to utilize this opportunity to inform Mr. Sachs that should he decide he does not want to represent himself and instead decide that he wants appointed counsel, that he is entitled to competent counsel. He's not entitled to the counsel of his choice. He's also not entitled to counsel that will do his bidding for him and file whatever he wants them to file. Attorneys have both ethical and professional rules of conduct that they must abide by and have a duty to the court and their profession to only file meritorious motions and bring forth meritorious positions, which are positions that are codified in statutes, the Constitution, and legal precedent. Furthermore, a defendant is not entitled to reject his court-appointed counsel and request substitution of other counsel absent a showing of adequate good cause. Junior versus State, 91 Nevada 439. Good cause does not encompass a mere loss of confidence by the defendant. Gallegos versus State, 117 Nevada 348. Disagreements over trial strategy are insufficient to allow for a substitution of counsel where counsel's strategy is reasonable, especially if the defendant's strategy is ill-conceived and largely impermissible. Good cause exists only when there is a complete breakdown in communication or irreconcilable conflicts that would lead to an unjust result. Furthermore, a defendant cannot create the conflict by refusing to cooperate with counsel or asking counsel to file improper motions and then stating that there is a conflict because the attorney will not do what the defendant wishes them to do. Again, every single one of the attorneys that has been previously appointed to Mr. Sachs has been competent counsel. Mr. Sachs's refusal to cooperate with that counsel, or thinking that he knows the law better than them, or them refusing to file something that they knew was without legal merit, does not and will not in the future be good cause for this court to appoint new counsel. As it pertains to Ferretta, again, the court must decide whether your waiver at this time in the proceedings is knowing and voluntary, and thus will go through another Ferretta canvas. Your objection for the record is noted. As you stated in paragraph 6 of your motion, the Nevada Supreme Court has, and this is from your motion, the Nevada Supreme Court has long held that a defendant's Ferretta waiver, once validly made, stands as a constitutional election that the court must honor unless the defendant affirmatively withdraws it or it becomes demonstrably incapable of continuing. Hooks versus State. The court in Hooks versus State, the court reaffirmed that a criminal defendant must knowingly, intelligently, and voluntarily waive the right to counsel, and that trial court should conduct a careful canvass to ensure that the defendant understands the disadvantages of self-representation, including the risks and complexities of the particular case. Likewise, in Graves versus State, the court clarified that the test of a valid waiver of counsel is not whether specific warnings or advisements were given, but whether the record as a whole demonstrates that the defendant understood the disadvantages of self-representation. Mr. Sachs in his motion stated as his conclusion that he met this standard. However, again, he affirmatively withdrew his constitutional election prior to trial the last time when he asked this court to appoint counsel based on his misunderstanding of what standby counsel could do. In his current motion, he requested standby counsel in the motion to withdraw prior represented counsel. He affirmatively stated that he requested standby counsel to, and this is in section F of his exhibit 1 to his prior motion to appoint standby counsel. Provide technical and procedural assistance as requested during pretrial matters to include but not limited to the jury questionnaire, voir dire, and the jury instructions to be used by the jury during deliberation. Provide technical and procedural assistance as requested for a file review if one is conducted necessary, and to provide assistance as needed during the file review, whether in person or remotely. Provide technical and procedural assistance as requested regarding a pretrial memorandum if one is required, necessary, beneficial to his defense. Provide technical and procedural assistance as requested for a calendar call and to be present to provide assistance as needed during the calendar call. Provide technical and procedural assistance as requested regarding pretrial motions in limine. And this was on page 2 to 3 of his motion filed on July 16th, 2024 as exhibit 1. He also indicated that he would need standby counsel to retain medical expert witnesses. And it was on this basis that the court previously appointed counsel because that was not the role of standby counsel. You further state at page 4 that all the roles, responsibilities in paragraph number 6 above are consistent with his constitutional right to being able to obtain a fair trial. But these are rights and responsibilities that would be incumbent on court-appointed counsel, not standby counsel. As this court has previously explained to Mr. Sachs, the role of standby counsel is limited. It is to protect the integrity of the trial and to take over for Mr. Sachs during the trial should he become unable to continue in the role of self-representation based on the integrity of the trial somehow being compromised. Therefore, since it was clear based on the prior filings that he could not effectively represent himself, and by his own actions, he affirmatively withdrew his constitutional right to self-representation, it is absolutely appropriate based on that for this court to hold another phoretic canvass. Because this court, i.e. this judge, needs to make a determination at this point in time that he is intelligently, competently, and voluntarily waiving his right to representation, court-appointed representation. I cannot just rely on what happened in the past, especially since that was over 2 years ago, and much has happened since then. So I will ask you again, based on everything that the court just said, do you still wish, knowing what the role of standby counsel is, that the court just explained and that the court has previously explained, do you still wish to go forward with the phoretic canvass and have this court make a determination that you will be, after we go through the phoretic canvass, that if the court finds that you are knowingly and intelligently and voluntarily waiving your right to court-appointed counsel, that you will be appointed standby counsel if you so choose, that will be limited to protecting the integrity of the trial proceedings and will not be doing what you had previously thought that standby counsel would do? Or do you wish for this court to provide you with court-appointed counsel?
I want to go forward with the Feretta canvas and also add that you leave me no choice and that I need to clear up the record on a couple things that you said, because you were talking for a while, is that with respect to your derogatory comment that I berated your staff, just to ask a simple question, because asking a question is not berating staff. I asked them, why are we being called last? And under what specific authority were we being called last? And so I was ignored. And so when I'm ignored by your staff, who have a duty to at least respond because I have open access to the courts, is that it is taken as a due process violation. So that's how I perceive it. With respect to your saying twice you said, I had a blatant misunderstanding of standby counsel, which is extremely upsetting because you actually read what I filed before. You put it on the record. You were quoting what Judge Kearney told me. And what you told me is she made a mistake. And I said, how can you make a mistake? And you said, well, we're judges, we make mistakes. And so for you to put it on me, not once but twice, to say that I have a blatant standing of standby counsel is completely ludicrous. Now, the third thing is that you said I have had all competent counsel. I need to go through very quickly, quick synopsis of how that is completely false. The first one was Mike Anello, who was a prosecutor from Florida that got promoted to being a prosecutor in Northern Nevada. And he tried to find a gadolinium toxicity expert, but he didn't find one, but he got promoted. So he was the first one. The second one was Roger Bailey. And Mr. Bailey didn't call me in a span of a whole month. And so for you to sit there and say, oh yeah, I've had nothing but competent counsel, that's not factually true. I'm just going to put it that way. So he didn't call me, and so I basically had him fired. I requested, say, go ahead, file in your motion to withdraw yourself. You're worthless. And then the third one was Mr. Ben Nadig. Mr. Ben Nadig, who likes to do it his way, like Frank Sinatra told me. He said, I'm only going to get ready for your case 3 weeks before the trial. Now, how is it possible when it took so long to get Dr. Smelka lined up that Mr. Nadig is going to pull off a miracle that he's just going to be able to magically get a gadolinium expert in a matter of 3 weeks so I can have a fair trial. So I asked him in the course of 8 months, because he wasted 8 long months of my time. He wasted it because I kept after him and I put an extremely detailed motion to have him withdrawn. It was unbelievably detailed. And so all he did was waste my time, and I asked him 10 times. I said, when are you going to pursue a gadolinium toxicity expert? Did he ever answer me? No, he did not. There, that's him. And then we get to Ben Bateman. Ben Bateman was standby counsel. And so we had a phone conversation where I asked him a couple technical questions of his understanding of the law, and he failed miserably. And I told him you failed miserably, and he said, we're done. I said, yes, you're right, we're done. Now, the next one is Mr. Goodwin. So to his credit, and I'm going to be fair to him, I'm going to be very fair to Mr. Goodwin in this record I'm making now. Mr. Goodwin was the best of the bunch. However, this is the big however, is that on September 8th, when he stood there and let Ms. Rinetti lie on the record and say that she found no contact orders, which was in fact the 2019 summons, because the summons is not an order, and anything that's handwritten on a summons is procedurally defective for my research. And so that's my position. And so you have a summons, not an order, that was used as a pretext to issue bench warrants where both counsel were standing there basically clueless, because you're all deemed to know the law. You are all officers of the court. You're all deemed to know the law, and you don't even know your own NRSs. That I come to find out after the fact that there's NRS 178.4845, paragraph number 4, which says even if you had a no contact order, it would have been void. It would have been that would have been void. That would have made the no contact order void in 2021. So as far as I'm concerned, the bench warrants were fraudulent right from the get-go. And of course they were quashed, so that proves the point. And so the point to make about that is that Mr. Goodwin knew that Monday of the hearing, when you turned it over, say, I'll hear from counsel, that he knew exactly what to say. That means he knew over the weekend or sometime before that hearing, he knew exactly what he was going to have to talk about. And that was the fact that, yeah, I looked in the record and, I couldn't find a no contact order. Right. He couldn't find it because it didn't exist. It never existed. And as far as we're on the topic of orders, I do need to make this record as well. This court's constant reference to CPS orders, and again, you are all deemed to know the law, so you have no excuses, is that CPS doesn't issue orders. Juvenile court judges do. And so it would be incumbent upon a juvenile court judge to issue any kind of order. And in this case, it would have come from whom? It would have come from Judge Giuliani. So you have access to all those records and nobody could find it. But yet you issued fraudulent bench warrants and you completely disrupted the life of my wife and I and caused this unbelievable misery and thousands of dollars in damages. And that will be addressed later, I promise you. So the last thing I want to say is regarding my judicial notice, and you kept referring to it even in this hearing as a motion. I titled it as a judicial notice, not a motion. And you may say, well, that's not a big deal. Attention to detail does matter because I've caught you in many instances that have already been documented to the fact that you violated literally hundreds, you committed hundreds of violations already that I've already documented. And so for you to get that wrong, once again, it reaffirms the fact that you don't get facts straight. And so my question is this, what I'm leading up to is this. The case law that I put in there that supports my position, how do you reconcile that case law that supports my position that says I do not need to go through a third Ferretti hearing versus your case law? Because what do we have? We have a conflict here, right? And so the rule of lenity says if you're not doing something right, you err on the side of the accused. So my question again is posed is, how do you reconcile the case law that is in the affirmative that supports the fact that I don't have to go through a third Ferretti canvas?
Are you done?
Yes.
I would like to address each one of your points. So I will start with the first point that you made about your statement in regards to taking issue with the fact that the court used the term berating your staff for not responding to your what was contained within the chat. You asked a question, you continued to ask the question. The court had actually addressed your question and stated to you that the reason that it was calling your case last was based on judicial economy, because I thought that it was going to take a significant amount of time. We started this hearing at what time, Shannon? What time? 12:10. It is currently 12:50. So we've already spent 40 minutes in this hearing. I knew that this was going to take some time. And so that is why, based on my ability under the judicial canons and under the judicial rules to govern my courtroom accordingly, I have the right to call cases in the order that I feel is the most appropriate. And so that is my authority for doing that. And so I simply stated, and Mr. Shetler was here in the courtroom. Mr. Gilliam actually walked over to him because he did not hear me. And I said that I was going to be calling your case last for judicial economy purposes. So that answers that question. As it pertains to me saying that you had a blatant misunderstanding, I understand, and I have said this previously before, in regards to standby counsel. And I understand that you were quoting directly from what Judge Kearney had told you before. My point was simply to explain to you that what you had previously been told before was not what the role of standby counsel is. And so if you are going to go forward on your own and choose to represent yourself, then it is incumbent on you to do the things that you had originally believed were going to be things that standby counsel was going to be able to do. So I am simply, and that is the reason why I am holding another Ferretta canvas, because I want to make sure, because obviously you had been given wrong information before, and therefore to the extent that Ferretta requires, and our case law interpreting Ferretta in this state, which the court cited to you, requires a knowing, intelligent, and voluntary waiver of your right to counsel. If you believe that standby counsel is going to be able to do certain things for you, then clearly they can't. And then clearly it is not a knowing and voluntary and intelligent waiver of your right to representation, because your belief would be that standby counsel could do things that they are not able to do. And so that is the reason why I brought up the fact of what you originally thought that standby counsel could do. And that is why I believe that it is appropriate to make sure that you are in fact explained under another Ferretta canvas what the requirements are for you to do, because otherwise it would not be a knowing and voluntary and intelligent waiver. So that deals with that issue. As it pertains to 178.4845, I understand that there is a motion that is filed that's going to be on, I believe, relatively soon, or it was titled as an objection. I saw it this morning. I was just getting ready to pull it up because it dealt with the other issue too. So there was a objection and motion to vacate the orders entered at October 20th, 2025 hearing for judicial misconduct. And to the extent that there was an objection to those orders and the court has not reviewed it yet, in full, but I did glance over it and I believe that there was reference to 178.4845. And there was also an additional, I believe, hold on here. There was a motion that's also set for November the 5th, motion for the court to take judicial notice of NRS 125A.085 and RS 125A.305 and NRS 178.4845. So to the extent that the court saw both of those motions and addressed during the last hearing that to the extent that there was a pretrial release condition that was entered, and contrary to your allegation, Mr. Sachs, that the court has access to the family court proceedings, this district court does not have access to the family court proceedings in a lot of cases, especially if they are sealed cases. Now, I don't have a case number that has been provided to me of the family court case. I don't know that family court case. I have not seen that family court case, so I don't know if there were orders that were entered into that family court case. That was why at the last hearing when we were here, I very specifically said to the prosecution that it would be very nice if there was an order from the family court case that the court be provided with that order. As of yet, that has not happened. That being said, to the extent that the court addressed this at the last hearing under 178.4845, because the statute, when it was changed, there is case law that doesn't make it retroactive. I don't believe that it would have had an effect on a prior order of a no contact. That being said, though, that is not in front of the court. I simply state that in response to what Mr. Sachs had said. As it pertains to the other counsel that has been provided, I understand that Mr. Sachs does not believe that that counsel was competent. And I will note for purposes of the record that when this court originally got this case, when it was transferred to me in 2024, it was at that time that Mr. Sachs was representing himself. That's when he sought standby counsel. That's when Mr. Bateman was appointed. And then subsequent to that is when Mr. Goodwin. So I have only been around for Mr. Goodwin and Mr. Bateman, and as of late, Mr. Marchese. I was not aware of any of the other attorneys, and what I know what your allegations are, Mr. Sachs, from reading some of the pleadings in the case, but I do not have contrary affidavits or hearings that have been provided in regards to those attorneys. So I will leave it at that. I believe both parties have made an adequate record at this time. I am going to go ahead and begin the Ferretta canvas unless Ms. Rinetti and or Mr. Shetler have anything else to say.
I need to clarify the record, Judge, before we get started, please.
What would you like to say?
There's a couple things. It won't be long.
Go ahead.
NRS 178.4845, the way it reads, it says right at the very beginning, it says, it is coming from a victim who wants a no contact order. It was never designed to act as a preventative measure for parents to be denied their parental rights. And again, those two statutes that are in that judicial notice make it crystal clear. This court, and you admitted during the last hearing, you said, I tend to believe, or I tend to agree with Mr. Sachs that I don't have subject matter jurisdiction because the boy's not here, that you admitted the same, but you went ahead and you completely disregarded those two statutes. So I just want to make that point for now. The other thing is that you said just now, it would be nice if you had an order from CPS. That's not what you said. You said you would love to have an order, which completely invokes the understanding that you want to punish me and my wife, and that is prima facie evidence of bias. And then the last thing is that as far as any orders from Judge Giuliani, that would have been Ms. Rinetti's job to get any so-called order from Judge Giuliani. And to my and my wife's knowledge, there has never has been an order from the juvenile court Judge Giuliani that said we could not have no contact with our son. And the last point I want to make about this, it is completely ludicrous for this court to somehow say it has authority over our son when our son was poisoned by gadolinium. And then, in other words, it was caused by the doctors, but yet we, the parents, are going to be penalized for all these years that we can't have any contact with our son. Is completely ludicrous. And again, it gets back to Arkansas has jurisdiction over our son. It's plain and simple. It's black letter law. It's black letter law. This court doesn't have any jurisdiction, and you don't have jurisdiction over our parental rights. You do have jurisdiction over the criminal matter. I will concede that, okay? But you are conflating the two, and you have no authority over our son. You have no authority. You have no power, no jurisdiction. Jurisdiction means power. You have no jurisdiction over him in Arkansas. He's an Arkansas boy and has been ever since 2019, and we are Arkansas parents. So I want to make that point loud and clear, because going into the next motion, I don't want to hear this stuff like you're going to conflate the two again and completely deprive us of our rights, because this court has taken on the appearance, because it completely disrespects and doesn't respect the rule of law, that this has devolved, as far as I'm concerned personally, as a kangaroo court. Just completely doesn't respect the rule of law.
NRS 178.4845 says, before a court makes a determination of bail concerning a person, a victim may request that a court issue an order imposing a condition of release prohibiting contact. A court shall consider a request described in Section 1. I am allowed under that statute to impose, and under various other statutes, Mr. Sachs, the court is allowed to impose conditions relating to bail. To the extent that you believe that the court's use of the word love is somehow imposing bias, that was not what the court meant. What the court was simply trying to say is it would be helpful to the record in this case if the court had everything in front of it that would support your side and or the state side in being able to make cognizant, educated, and well-informed decisions. I have made it very, very clear on numerous occasions. If you thought that I was biased against you, I am not. That is the reason why, we went forward with the motion hearing on the motion to strike Dr. Smolka. If you wanted to honestly believe that I was biased, you would probably have thought that I was going to grant that motion and strike him. The court did not do that. But to the extent that you keep on making allegations that your son was poisoned by gadolinium, I understand that that is your position. I understand that you have a doctor who is prepared to testify to that fact. That is not up to this court to decide. I do not sit as the fact finder. That is up to a jury to decide as to whether or not they believe Dr. Smolka or whether or not they believe the state's experts. That is not for this court to decide as to how your child got into the condition that he got into. As it pertains to this court's jurisdiction, this court has jurisdiction over the criminal case. And furthermore, if there was, in fact, an order, and you knew, because obviously your child was taken by CP, and I'm not even going to say your child, I'm going to say your stepchild, because I want to be 100% entirely accurate when I speak to you. It is Miss Zhang's child. It is your stepchild. To the extent that that child was put on an airplane back when this case started by CPS, they would not have done that if there would not have been an order that allowed CPS to remove that child from your home. So, based on that, to the extent that that is what happened, you knew at the time that you went and got this child, or at the time that this child was returned to you and the mother, Miss Zhang, by the father. I do not know how this child got back into the country. That there was at least at some point in your thought process that there had been a removal and it was inappropriate without something further from either the family, and it's not the juvenile court, it's the family court, either the family court or this district court, that there needed to be something done in order to reestablish your ability to have contact with that minor child. That being said, that is not in front of me. I simply say that in response to what your arguments were. We are going to go forward with the phoretic canvas at this point.
Excuse me, Judge, I have a right to be heard.
No, we're
I
done.
object. I object that I cannot make a clarification on what you just said.
Mr. Sachs, I am not going to continue to go back and forth with you. We've been doing this now for an hour. I am not going to continue to go back and forth with you on your wanting to contradict what this court is saying. I believe you have made an adequate record, both in writing as well as in your verbal responses. I understand that you do not agree with this court's findings. I understand that you do not agree with this court's decisions. The court has made its decision. We are going to go forward with the phoretic canvas. Anything else, if this court decides that you have knowingly, intelligently, and voluntarily waived your right to counsel, then anything else that you wish to address, you can do so in writing. You have made a request to proceed without a lawyer representing your interests. Is that true?
Yes,
Do you understand that you have the right to have a lawyer represent you and that the court would appoint a lawyer for you at no cost if you cannot afford a lawyer?
question. When you use the word here, the way you're using it, understand, do you mean it to say, do I stand under, or I comprehend the meaning of the words?
Do you comprehend the meaning of the words? Do you understand the concept?
Repeat the question, please.
Do you understand that you have a right to have a lawyer represent you and that the court will appoint a lawyer for you at no cost if you cannot afford a lawyer?
Yes.
Hold on 1 second. And so that we are all on the same page, because I believe that miscommunication and misunderstanding happens at a very base level of one party or the other not being on the same page of definitional words. Understand, according to Merriam-Webster, means to comprehend, appreciate, to have a clear or complete idea of.
Thank you for the definition.
You're welcome. Have you thought this matter through, and are you certain that you wish to proceed without an attorney?
Yes.
Are you currently under the influence of any medications, alcohol, or drugs at this time?
No.
Do you currently suffer from any mental diseases or defects that would render you incapable of understanding at this time?
No.
Have you ever had any mental health issues?
No.
Have you ever had any competency issues?
No.
Do you have any physical health issues that prevent you from understanding the proceedings that are happening here today?
No.
Are you a United States citizen?
I'm a state national.
You were born in the United States, is that correct?
That's correct.
You are legally allowed to be in the United States, is that correct?
That's correct.
You are not subject to any deportation or immigration issues. Is that correct?
No, I am not.
Do you understand that a lawyer would have experience in handling criminal matters and in particular handling criminal jury trials?
Yes.
Do you understand that you have a constitutional right to have an attorney to advise and represent you at all times?
Yes.
Do you understand that that attorney would be able to file pleadings on your behalf, subpoena witnesses, represent you at trial, do investigations?
Yes.
That that attorney would talk to witnesses, study the law, and defend you at trial?
Yes.
Do you understand that no one can take that right away from you?
Yes.
Do you understand that a defendant who represents himself may impart to the jury a negative feeling since a lawyer would not be present to handle your case?
I don't necessarily agree with that, but I comprehend the meaning of your words.
Okay. Have you ever represented yourself before in a criminal trial? I understand that during the course of this case that you have in fact represented yourself at various different stages during this case. I want to know very specifically, have you ever represented yourself at a trial?
No.
Do you have an educational background in legal matters? And what I mean by that is, have you ever received a legal law degree?
No.
What is your educational background?
I have a bachelor's degree in finance from Penn State, and I've studied Nevada law against my will for over 6 years. And I actually, as a layman, I studied the Nevada Rules of Appellate Procedure, NRAP. I studied it for 2 weeks, and I wrote a very worthy writ of mandamus to have the grand jury reconvene under NRS 172.241 and found out that they are completely lawless as well.
I understand that that is your feeling. Do you have a general understanding of the English language?
Yes.
Do you have any legal training other than what you have done for yourself?
No.
Are you familiar with the 8th Judicial District Court rules?
Yes.
Do you understand that there are rules controlling the way a criminal case proceeds through the system and the way that criminal trials proceed?
Yes.
Do you understand that you will be bound by the same rules as anyone else who would be involved in a similar matter, including attorneys?
Yes.
Do you understand that you will be held to the same standard as any lawyer who might appear in a similar matter representing a client?
Yes.
Are you familiar with the rules of evidence that are used in the state of Nevada?
Somewhat, but as the expression goes, I will bone up and study on it because I'm more than capable of such things. Because as a layman, I wrote again a very worthy writ of mandamus, and I never knew anything about doing that before. And when I called other attorneys for them to give me quotes on what they wanted, and a lot of them said to me, "Gee, I've never done it." So I'm like, "Okay, so you went to law school, you never did it, but I did it." So the answer is more than yes on any of these say minutia details that I may not be intimately familiar with right at this exact moment, but I can assure you I will be up to speed when the time comes because we don't even have a trial date at this point.
Do you understand? I'm sorry. Are you familiar with the rule? You said that you will bone up on the rules of evidence. Do you understand that the rules of evidence control what evidence may be introduced at the trial in this case?
Yes.
Do you understand that you will be required to follow the rules in the same way as any other person who would appear in court?
Yes.
What does that mean to you in your own words?
That you have statutes, rules, local court rules, the rules of criminal procedure, that sometimes they work independently, sometimes they work together or complement one another. That for me to be able to accomplish what I need in my defense, I will have to be familiar with all of them and execute them properly.
And do you understand that if you are not familiar with them at the time of trial, that you don't execute them properly, that could mean that certain evidence that you would want to have introduced into this case would not be admissible at the trial?
Yes.
Do you understand that the rules that we follow may make it difficult for you to ask questions in a way that you might wish to ask a question?
Yes.
Do you understand that since you are not currently familiar, and I understand that you said that you will make yourself familiar with the rules of evidence, you may not know the appropriate way to frame a question, and that this may cause you problems or objections from the state when you ask a question that would make it so that you could not get the question to the answer that you want, or the answer to the question that you wanted?
Yes.
Do you understand that the court will not function as your attorney?
Yes.
Do you understand that the court will not give you any legal advice or assist you in any way other than potentially providing you with procedure?
Yes.
Do you understand that you will be held to the same rule as the prosecutors in this case?
Yes.
Do you understand that the fact that you may lack personal knowledge of the court rules, procedure, and the rules of evidence will not be a reason for the court to ignore those rules or procedure?
Yes.
Do you understand that if you represent yourself, you will give up the right to later claim that you did not have effective and proper legal counsel?
Yes.
Do you understand that you may lose an appeal on evidence, issues, or any other part of the trial because you do not know how to make proper objections?
Yes.
Do you understand that you are charged with, let me pull up, so because you're always making sure that we are citing to the appropriate. Hold on, I just closed out and I didn't mean to do that. Do you understand that you are charged with child abuse, with 2 counts of child abuse, neglect, or endangerment resulting in substantial bodily harm, and 2 counts of child abuse, neglect, and endangerment, and 1 count of child abuse, neglect, or endangerment resulting in substantial bodily harm?
I understand that I am falsely charged with those. Yes.
Do you understand the element, do you know what the elements of those crimes are and what the state would have to prove?
Yes. It says a person who, these are the elements because it just reads, it says a person who willfully caused a child who is less than 18 years of age to suffer unjustifiable physical pain or mental suffering as a result of abuse or neglect, or to be placed in a situation where the child may suffer physical pain. And the burden on the prosecutor is beyond a reasonable doubt.
Do you understand the sentencing ranges for those crimes?
If it has substantial bodily harm or mental harm results, not less than 2 years and a max term of 20 years. If substantial bodily harm does not result, not less than 1 year or a max term of 6 years.
Do you understand that if you are found guilty of one or more of these crimes, this court could order that the sentences be served either consecutively or concurrently?
Yes.
Do you understand that the total amount of sentencing that would be available to the court if you were found guilty of all 3 of these charges and the court were to run it consecutively, therefore would be potentially 4 years to 32 years?
Yes.
Do you understand that you would need to, prior to the court allowing you to have probation on these charges, even if you were found guilty, that there would have to be a danger evaluation and that you would have to come back as a low risk to reoffend in order to be able to be granted probation?
That's my understanding from the previous two Feretta hearings, so the answer is yes, and I don't agree with it, but I understand it.
And Your Honor, I hate to interrupt you. It's as long as he's not deemed a
High risk to reoffend, right? So it's actually, you would just have to be found not to be a high risk to reoffend. You understand that?
Yes,
Do you know what defenses that you can present to the crimes in this case?
well, there's affirmative defense for one, and there is the defense I've already laid out that it was the hospital that poisoned my boy. It's very simple defense.
Do you understand that there may also be other certain affirmative defenses or mitigating evidence, and that your lack of knowledge of their existence or your lack of knowledge of the appropriate procedure for introducing that evidence of those issues would not be grounds for an appeal if you did not address the appropriate issues?
Yes,
Do you understand that an attorney may be aware of ways of defending these particular charges that may not occur to you since you are not an attorney?
the answer is yes, and I had that discussion with Mr. Goodwin at length, so I'm quite familiar.
Do you know what lesser included offenses are?
Lesser, what was it?
Lesser included offenses. Do you know what that means?
I have a vague idea, but as my understanding is the lesser offenses is if they reduce it from a felony to misdemeanor. That would be my best guess at this point without looking that up, but it's easy enough to look up.
Well, it could also be, for example, you have a child abuse, neglect, or endangerment resulting in substantial bodily harm. The lesser included offense of that could be just the child abuse, neglect, or endangerment. Do you understand that?
Yes.
Do you understand that I cannot give you advice about these matters?
Yes.
Do you understand that if you represent yourself, you are on your own? I cannot tell you or advise you as to how you should try your particular case.
Yes.
Do you know what jury voir dire is?
Yeah, it's jury selection where you disseminate the questionnaire, and then you have a pool of people, and you ask your questions. You whittle them down until you get your 12 plus your two alternates, basically.
Do you know that this court no longer does jury questionnaires? So we don't send out jury questionnaires ahead of time to the extent that they used to be prior to COVID. Are you aware of that?
That I wasn't aware of. When
Okay.
did you said prior to COVID? So that was 2020 when that happened?
Correct.
All right.
So now you will just get a jury panel that has some limited biographical information that lists their age, where they're employed. What else is on there? I'm trying to see if I've got one here from my packet from before. That, no, that's not. No, that's just a small packet. Anyways, there's just some very basic biographical information. It doesn't go into depth the way that the prior questionnaires would. So there would be additional questions that the court asks as well as that you would ask. Are you aware of how to go about doing that so that they are not objectionable?
I will, as the expression goes, as I used before, I'll bone up on that. I'll study it.
So as it stands right now, you do not know how to go about the process of selecting a jury?
Well, I know you get peremptory challenges and you get for-cause challenges. I'm somewhat familiar, not intimately familiar. And so I have the gist of it. I understand the gist of it. And from there, I get into my my nose in the book, so to speak, or whatever it is. And I figure it out and I read and I understand and I comprehend.
Okay. Do you know the difference between an opening statement and a closing argument?
Yes, the opening statement is saying the evidence is going to show X, Y, and Z. And the closing statement, the essence of it is that the evidence showed X, Y, and Z.
I know we spoke briefly about how to go about admitting evidence. You indicated that you would bone up on that. So as we currently sit here right now, do you know how to go about admitting evidence?
Well, my understanding is you have to lay a foundation for it, and then you have to properly label it, and then you get it admitted. That's my gist of it. But again, I will read up on it.
Do you know what the state's burden of proof is?
I said it before, it's beyond a reasonable doubt.
Do you know how to submit mitigation evidence at sentencing if you were to be convicted?
I'll research that. As of the moment, the answer is no, but I'll research it.
Do you understand that you must proceed by asking questions of the witnesses that will appear before the court?
Please repeat the question.
Do you understand that you must proceed by asking questions of the witnesses that will appear before the court? In other words, you can't just make statements to the witnesses. You have to have a question and answer format. Do you understand how to go about doing that?
Yes.
You understand that you will not be permitted to simply argue with the witnesses.
Yes.
You understand that unless you decide to testify on your own behalf, you will not be permitted to tell the jury matters that you wish them to consider as evidence other than through the making of an opening statement and a closing argument. Do you understand that?
Yes. Yes.
Do you understand that if you decide to testify, that you will be giving up your right to remain silent and you would be giving up your right to not incriminate yourself?
Yes.
You understand that if you decide to testify on your own behalf, you would be subject to cross-examination by the prosecutor.
Yes.
Do you understand that it may be much easier for an attorney to contact potential witnesses on your behalf, to gather evidence on your behalf, and to question witnesses on your behalf than it may be for you?
Yes.
Do you understand that it may be much easier for an attorney to provide legal research on legal questions that may come before the court than for you to do so on your own?
I will say this before I say yes, is that I believe my research from what I've done independently far surpasses anything I've had from counsel at this point.
Do you understand that if you represent yourself, you may limit or even give up certain issues that could be appealed to a higher court if you are found guilty?
Yes.
And specifically, what I mean by that is one that we have already discussed, your ability to be able to argue to a higher court that you did not have effective counsel.
Yes.
Do you know how to make a record for appellate purposes?
Other than my testimony, my objections would be part of the record. So it's everything that comprises testimony and evidence.
You understand that since you are not a lawyer, you may not know how to properly make the court record, which would cause you problems with an appeal, even though you would have a right to appeal and a right to a lawyer to handle an appeal.
Repeat that question, please.
You understand that since you are not a lawyer, you may not know how to properly make the court record, which could cause you problems with an appeal, even though you have a right to appeal and a right to a lawyer to handle an appeal.
I comprehend the meaning of your words.
Do you understand that you will be required to conduct yourself in a professional and respectful manner to the court and to all the witnesses involved in this case at all times?
Yes.
Do you understand that if you do not conduct yourself in such a manner, the court could revoke your right to self-representation and may have you removed from the courtroom if you become disruptive?
Yes.
In discussing this matter with you, I must advise you that in almost every case, it would be my opinion that a trained lawyer would defend you far better than you could defend yourself. It is almost always unwise for a defendant on trial to try and represent themselves. Again, you are not familiar. I know that you've done quite a bit of work in this case, Mr. Sachs, but at the end of the day, you still have not done a trial, and it is different. You are not familiar with the law. You are not familiar with handling a trial. You are not familiar with all of the court procedures. You are not familiar with all the rules of evidence. and I would strongly urge you to not try to represent yourself. Do you understand the court's position on this issue?
I do.
There is an old saying that a man who is his own lawyer has a fool for a client. Do you understand what that means?
Yes, but I vehemently disagree because Mr. Goodwin is a perfect example. He threw me under the bus and did state the most obvious NRSs that would have preempted your issuing fraudulent bench warrants. So that is completely nonsensical to me. It's absurd. It's ludicrous. Um, I, I've had enough discussions with the previous attorneys to know that I know for this particular case, I know the NRS is better than they do, and it has been abysmal to have to deal with individuals that went to law school and I didn't, and that they don't even know the NRSs that protect me or my wife and be a good advocate and keep us protected and keep us out of hot water, which clearly we've been failed a number of times already. So I think your premise is completely flawed. I don't agree with it.
Well, it wasn't my premise. It was actually Abraham Lincoln's premise, but I'm just asking the question. I understand your argument. Again, this court is strongly suggesting that you allow a legally trained attorney to represent you in this matter. Do you still wish to represent yourself?
Yes.
Are you making this decision freely and voluntarily?
Yes.
Do you have any questions that you would like me to clarify or explain further?
There is a question that comes to mind as far as what seems completely inequitable, that just because I change gears from full-time counsel to standby counsel, that I lose the benefit of, say, the PI, meaning Ken Hardy of Silver State Investigators, that in everything that would entail. And what, in other words, why should that be? How is that fair and equitable that by changing gears like that support is taken away from me and that's somehow considered fair and just? How is that?
Because court-appointed counsel has resources that are provided to court-appointed counsel. If you are not going to have court-appointed counsel, you are not entitled to those resources.
Can you cite an authority on that, please?
Taxpayer dollars?
That's not authority. I'm talking about an NRS or a case law.
I don't have an NRS. I simply know that court-appointed counsel has resources that are provided to them.
All right, I'm just going to say I find the answer unsatisfactory and I object to it.
Your objection's noted for the record. I will talk to you further. Would you like, since we have had a very long and in-depth conversation about what standby counsel can do? If you would like the court to appoint standby counsel simply for the purpose of protecting the integrity of the trial, not to file motions on your behalf, not to do your investigation on your behalf, not to file, and I do want to ask one other question, not to file the response to the writ that the state is intending to file, but simply to protect the integrity of the trial, the court would appoint standby counsel for you. Do you wish for the court to appoint standby counsel for you to protect the integrity of the trial?
Before I answer that question, I want to read a little bit from McCaskill versus Wiggins, where it says, and this coming directly from McCaskill and Wiggins, that is the controlling law for Nevada on standby counsel. It says, once a pro se defendant invites or agrees to any substantial participation by counsel, subsequent appearances by counsel may be presumed to be with the defendant's acquiescence, at least until the defendant expressly and unambiguously renews his request that standby counsel be silenced. That's one thought. Second thought is, Faretta rights are also not infringed when standby counsel assists the pro se defendant in overcoming routine, procedural, or evidentiary obstacles to the completion of some specific task, such as introducing evidence or objecting to testimony that the defendant has clearly shown he wishes to complete, nor are they infringed when counsel merely helps to ensure the defendant's compliance with basic rules of courtroom protocol and procedure.
Exactly.
Next is, but
Mr. Sachs, I'm going to interrupt you because I need to say this and then I will let you continue. But that is exactly right. And that is talking about the integrity of the trial. That is talking about what standby counsel would do on procedural matters at the trial. That is not pre-trial where they're filing motions on your behalf. That is not what standby counsel does. Standby counsel is there to protect the integrity of the trial. And that is what that is referring to in that case. You may proceed.
understood, but I never asked or said anything about pretrial motions. I'm more than capable of filing pretrial motions, as you should be well aware of. So I don't know why you raised that particular point. Coming back to it, but counsel need not be excluded altogether, especially when the participation is outside the presence of the jury or is with the defendant's express or tacit consent. Last, the Fifth Circuit made it clear standby counsel is not to compete with the defendant or supersede his defense. Rather, his presence is for advisory purposes only, to be used or not used as the defendant sees fit. So with that understanding, if you are, say, in agreement with what I just read from McCaskill and Wiggins, that the answer is yes, I do want standby counsel.
Okay. What I am referring to, and we've had this discussion before, is to the extent that in your Exhibit 1 to your prior motion to appoint standby counsel, that you were under the impression that standby counsel was going to do more than simply be with you at trial to protect the integrity of the trial or provide you with information on objections to evidence potentially. That is not what standby counsel is for. So I will again ask the question. Would you like the court to appoint standby counsel for the purposes of being there at trial to protect the integrity of the trial?
Yes.
The court will appoint Michael Sanft as standby counsel.
Please spell his name.
S-A-N-F-T.
When is Mr. Santh going to call me, please?
He's not going to call you. He will show up at trial and he will be there to protect the integrity of the trial. That's what standby counsel does. He does not need to call you. He is not there. That is the whole purpose behind what they are saying in McCaskill, because what the court is focusing on is you have a right to self-representation. And standby counsel, it would be inappropriate for standby counsel, and it would be reversible error for standby counsel to come in and usurp your ability to represent yourself. That is exactly what that is referring to. So to the extent that you are representing yourself, you are representing yourself. He will only be there to protect the integrity of the trial. The court finds, based upon the totality of the circumstances, that the defendant has waived his right to counsel knowingly, intelligently, competently, and voluntarily, as he desires to waive the right to representation by an attorney and to represent himself. The court further finds that the defendant has a full appreciation and understanding of the waiver and its consequences. Accordingly, it is so ordered that the defendant's waiver of the right to counsel is accepted. That concludes the proceedings for today.
I need to make a couple of questions for the court, and I apologize. So I have three things.
Okay.
First one, based upon earlier conversations regarding family court records and things like that, I have instructed my staff to file an ex parte order for Child Protective Services records that will come to chambers.
Okay.
We will ask them to be distributed to the state as well as to Mr. Shetler and Mr. Sachs.
Okay.
Because he represents himself, I just like this court to admonish the defendant, whatever records that you give, these are confidential records. They cannot be disseminated in any way other than to his standby counsel. It would be against Nevada law to distribute those, whether electronically, via YouTube, anything to disseminate those confidential records.
Mr. Sachs, you understand that the court has ordered CPS to produce records relevant to the underlying proceedings in this case. Those records are confidential records pursuant to Nevada law. I know that in many of your motions that you have filed in this case, that you have attached exhibits. It would be inappropriate for you to attach those CPS records as exhibits. It would be further inappropriate for you to disseminate those records to anybody other than your standby counsel. Do you understand that?
Yes, but please have the court or the prosecutor, she said it's Nevada law, specifically which one, please?
I don't need to do that. It is CPS records are confidential, sir.
The rule, your decision has to be based on a rule or foundation or statute. It can't be this willy-nilly like hearsay like that. That's unacceptable. I object to that, please.
It's NRS 432B. The
Thank
second
you.
thing that I'd like the court to be aware, I have disseminated the order denying the state's motion to strike Dr. Similka. I gave it to both Mr. Marchese, Mr. Goodwin, and Mr. Shetler. Mr. Shetler is in agreement with the order.
Okay.
Now the defendant represents himself. I just would like to know from the court, would you like me to email both your chambers and Mr. Sachs a copy of the proposed order? And then if he has any issues with it, he can submit a competing order. However the court would like me to proceed on that.
So, Mr. Sachs, because your wife is currently represented by Mr. Shetler, I do not know if you have had an opportunity to review the order that was submitted, if your wife actually received that or not.
I received it. There only seemed to be one correction that needed to be made as far as I'm concerned. The rest of it looked all right to me.
All right, so I would ask that you send that one correction that you have via email to Ms. Rinetti. You don't need to go into any depth about anything else, simply the correction that you wish to have corrected. If Ms. Rinetti agrees with that correction, then she will respond that she agrees with your correction. If she disagrees with your correction, then she will simply say that she disagrees with your correction, and she will submit to the court the email that indicates what the correction is that you wish. The court will review that correction. If the court agrees with the correction, the court will interlineate the order that is going to be submitted to the court. If the court does not agree with that correction, the court will not interlineate the order, will left side file so that it is for purposes of the record, will left side file your correction into the case. Number 3.
Number 3. Defendant Sachs has filed numerous motions.
Yes.
There are multiple court dates. I think at the last court date, I asked, can we wait until the FREDA canvas before the state has an obligation to respond? What
Yes.
I've asked this court to do, if we could set a briefing schedule, allowing me some additional time based upon the numerous motions.
Yes.
If we could do a time for my oppositions, the defendant's replies to any of my oppositions, and then a hearing date, I would very much appreciate it.
And I will note that there are approximately 4 motions that are currently set for November the 5th. This court is currently in trial. To the extent that I believe that it would be appropriate based on the length of the hearing that we've had today and based on prior lengthy hearings that we have had in this case, I believe that it would be appropriate to set this matter on a special setting. So therefore, what I will do is you have your statutory timeframe under the Nevada Rules of Criminal Practice, which would be 10 days from today, to file any oppositions to the motions that have currently been filed. Mr. Sachs will then have time to file his reply. I will give him 10 days to file any sort of reply. Mr. Shetler, any joinders that you wish to file, you can certainly file those within that 20-day time frame, I believe.
Yeah.
And that would take us, if we go 20, let's set a hearing date for 30 days out. That gives the court 10 days after everything has been sufficiently briefed for the court to be able to read and review everything to be prepared for said hearings. So that would take us out to November the 29th, would be 30 days.
That'll be this Saturday.
Which is a Saturday, so let's go to, can we do what's on for the following Friday?
We start the next,
What's on for the following Tuesday?
we're in trial basically. So we'll just have to pick a date.
Okay, so what I would like to do is, would you prefer a Tuesday or a Friday?
Court's pleasure.
Tuesday would probably be best if it's possible.
All right,
Do I get any input, Judge?
yes, I was getting there. If you'll give me a minute, I need to find the actual date that it's gonna be because you're not here, so I wanted to give you what that date would be.
December 16th.
Does December 16th work for you?
I'm going to say that I object to this because this is a massive waste of time. That the rules lay out that I file a motion, she has 10 days to respond, and then I have 3 days to do my reply to opposition. This is over 6 years old. And so I guess I do need to say this at this point because I probably won't get another chance at this, is that now that I am representing myself, and to make just a quick comment, that you allowed Ms. Rinetti during the September 8th hearing to make an oral motion to basically ambush us with bench warrants under false pretenses, is that I move this court at this time for you to recuse yourself, Judge.
Motion denied.
Okay, so thank you for that. Now, at this point, I make an oral motion that I'm disqualifying you for bias and judicial misconduct. And so I want to get that on the record right now, that I don't feel I'm ever in my life going to get a fair trial with you as the judge ever. It's not even remotely possible. So again, I am issuing a oral motion to disqualify you.
You cannot do an oral motion to disqualify pursuant to the rules. You have to comply with filing the affidavit and allowing the court, serving the court with your affidavit, your basis for disqualification, and allowing the court to respond to said affidavit. And then it needs to be heard by the district court judge. So to the extent that, or the chief judge of the district court. So to the extent that that has not been complied with, your oral motion is denied. If you would like to take the appropriate steps, you may do so. And if you took the appropriate steps, then it would further delay anything, because this court could not take any action pursuant to 1.235. So if you want to do that, you are certainly entitled to do so, sir. You can file the appropriate motion to disqualify, cite your reasons, serve it on the court. The court would then file its own affidavit, would stay the matter pending decision from the chief judge, and we would go forward based on whatever that decision was. If you decide to do that, that is certainly within your right, but your oral motion is procedurally improper and is denied at this time.
December 2nd.
I can do December 2nd at 9 a.m. if that works better for you.
The earlier date, please.
December 2nd at 9 a.m. Anything else that we need to deal with at this juncture?
Briefly, I'll try, Judge. Would it be possible to get the chat printed out and provided somehow into the record or circulated? I don't have a way to do that, but
Sure.
thank you.
Thank you. All right,
Thank you.
that'll be all. We're off the record.